Hey folks, John Cantera, the Double Broker Bounty Hunter here. Thank you so much for joining us again between the holidays. Some of you are at home, some of you have decided to brave the roads, but we are glad you are with us either which way. Hope your Christmas was fun and eventful with your families. As you can see, there is somebody missing here on the panel today. Kate is out sick, so we have with us today Jenny in a bottle. Who is acting as co-host with me. Jenny, always good to have you with us. How you been, my dear?
Good, good. Thanks for having me on, John. It's always a pleasure to be on your show. I'm glad to be here with Mr. Seaton. It's good. It's going to be a good discussion today. I can feel it.
Absolutely, absolutely. We're going to be talking a bit about the transportation legislative agenda for 2025 with Henry, and we probably going to learn a lot of things, like it or dislike it. It's always good to get an attorney's point of view on how things should be done in the industry. So let's go ahead and get this thing going.
Welcome to the Double Broker Bounty Hunters Stop the Scam. Here are your hosts, the Double Broker Bounty Hunter, John Cantera, and Dispatch Kate, Caitlin Price.
Another one bites the dust. Yeah, and as we already pointed out, Kate's not here, but that's okay. Still glad to have Jenny around. Before we get into our discussion, we definitely need to go ahead and pay homage to our sponsors. You need to be able to bid smarter, bid faster, and bid better with AccuBid Pro.
Do you know your cost per mile? Have you been hitting your profit margins? Do you struggle with bidding in a way that is both profitable and competitive? Would it be worth it to have all this information right in front of you? By calculating your cost per mile, AccuBid Pro helps you stay profitable in an industry still struggling to recover. In order to calculate your cost per mile, AccuBid Pro asks you questions about your business expenses. Our goal is to help you understand what you need to keep operating in order to keep up with the game and maintain your business. Enter your origin and destination, and we show you what you should bid based on your personal cost per mile in order to be profitable, even including a more detailed breakdown of each bid. Download the app today and get your 30-day free trial of AccuBid Pro, available on the App Store and Google Play. Bid smarter, bid faster, bid better with AccuBid Pro.
And as we said when we got started, we have a special guest with us today. We have Hank Seaton of Seaton and Husk here to talk with us about transportation law. Hank, how long have you been doing the law thing in this industry? Because that just scares the heck out of me.
Those of you who can see me can recognize I've got some gray hairs. I got all that from trucking. I've been doing it for 52 years.
John doesn't have any hair. Look what
Yeah,
happened to him.
52,
He pulled all his
52
out.
years.
I have some indicators on the face, but that's about it.
Yeah. No, my dad was a trucker, and I ended up going to law school. And at that point in time, in order to get operating rights to move freight from Pensacola to Birmingham, you had to have authority, and you had to prove public convenience and necessity, and that led to trials. And carriers were considered to be a public utility, and there was a lot of opportunity for trials. There was a lot of camaraderie. There was a lot good about it because every little town in the country was served by some hometown guy who probably took 2 trucks into a major city like Birmingham and picked up the material and took it home to Coleman, peddled it. This was a completely different setup. The idea of truckload carriers really only existed for heavy, bulky things, the few things that moved from a plant site. Distribution was completely different. It obviously was cumbersome and it needed reform. But when it was reformed by Congress in a very willy-nilly way that set us up for, in many respects, more problems than it did good.
And you're referring to the Motor Carrier Act of 1980.
Yeah. Yeah. Well, the Motor Carrier Act of 1980 really took about 8 years to be absorbed. because the ICC was still around. And the real issue that the new agencies lost sight of was they deregulated routes, rates, and services. That meant you got authority, you could go anywhere and you could haul anything, and you didn't have to go through a trial to get it. But they didn't deregulate safety, which became the government's mandate. It's only North Star, and a North Star that they haven't gotten to yet, nor rules of commerce. And the rules of commerce came through the entire system from the ICC, who understood how trucking worked, to a bunch of new guys that didn't know a tractor from a trailer. So all of the rules of the road, and I was happy to see that Jenny's got a copy of a book that I wrote in, I guess it was 2015. All of the rules of the road remained on the books. It was just an agency that couldn't enforce them and didn't try to. And the result of that, by the time the ICC was terminated and it was transferred over to the FMCSA, became that there was no one to enforce the rules of the road. Things like, there's one way to handle cargo claims. The thing called the Carmack Amendment. By law, it's accepted what is a cargo claim and what isn't, and people are able to limit their liability. But when you took that out of the law, it very quickly became law of the jungle. And as brokers were having their heyday with the loss of the file rate doctrine, you're all of a sudden seeing that carriers were being made to sign deals they couldn't insure. I don't want to use names, but everybody knows that when you've got the law of the jungle, it ends up being you need to get home from Keokuk and you end up having to sign anything that's jammed down your throat, whether it's fair or not. And that is the pet peeve that I've really got, is that I'm old enough and tired enough that I want to represent folks that want to work with each other in a level of honesty and integrity. So don't come to me if you're going to try to make a profit on the back of an owner operator. You don't view that owner operator as a business partner, and you don't view it as a lasting relationship, then go find somebody else. So I mean, those are the kinds of crotchety old men things that I kind of believe in. And so obviously over the past 15 or 20 years, the real issue has migrated from routes, rates, and service into fraud. The agency has been totally unable to get its arms around a safety fitness determination that gives a small carrier a fair chance to compete. You're required by Congress in about the year 2000 to give every motor carrier a test that would let the agency say that fit to operate is fit to use. They never could do it. They tried with SMS methodology. It went on for 20 years. They got nowhere with it. So as a result, a new guy who, let's say he's an owner operator and he wants to start his own trucking company, he can't get a stamp from the federal government that says that he's been vetted and is fit to operate. So he pays higher insurance costs. So he's looked at askance by the shipper because he is afraid he'll be up supply chain liability. And you just don't walk into it with the idea that you've got an equal opportunity to participate on safety. But on the fraud issue, which we're here to talk about, it's important that anybody getting into this understand that the underlying rules governing a broker have not been materially changed since before deregulation. What is still operative are the same rules with the same effect that were inherited by the FMCSA when it started operation. The only difference was fraud escalated because of the spot market and because people weren't doing business with accepted folks. And at the same time, the agency begun this notion of saying we have no authority to enforce anti-fraud. They have got a hotline that only runs cold water. They've got somebody that'll take down your bust, okay? But they don't do anything with it. They've got good people on their staff who probably grew up as a son of a trucker that understand the problem, but they basically are powerless to do it unless the people higher up do it. And I've been dealing with them long enough to know that ultimately, if a bureaucrat doesn't want to do something, don't try to force him. That's really pretty much a dead end. So that's how we kind of halfway gotten to the point that we're at today, and each year it seems to get worse.
It just exponentially increases every year. I watched. I tallied up one year. When I first started collections, the number of bad brokers reported for non-payment from November into the first 2 weeks of December. So for that 6-week period was, I think, there were like 18 of them the first year. The next year there was, I don't know, 25. The next year there was 60 some, and then the following year we were like in the hundreds, it seemed like. And so, I mean, it just seems like it's exponentially increased every single year over year, and it's no end in sight. It just continues to get worse and worse.
When you talk about the numbers, let me give you some perspective. In 1985, we had our first hearing in Congress, and I represented a group called the Ad Hoc Committee to End Broker Abuse. So you know the nature of the problem. Okay, now that was in 1985, so deregulation was just coming in. And in the hearing, the senator from Iowa who was conducting it had the ICC there, and he asked them, he said, look, these guys say there's a real problem here. Do you recognize it or not? And the guy from the ICC said, no, we really don't hear a lot of complaints. And they said, well, Mr. Seaton, what do you have to say in response to that? And I said, well, listen, I got 45 of them that I'll be happy to show to them. And I suggest that the reason they don't have any is because people know they're not going to do anything about it. So they had somebody from the ICC trip over to my office and look at these 45 complaints. And it was within the next year and a half they did away with the ICC. So any positive effect of that collapsed. But, every year it seems to increase. And even now, if we look to going to Congress and asking that the prosecution be turned over to Justice Department or somebody else, the first question is going to be, well, gee, how bad is it? And it's gotten so bad, and I think if we sat down and had a hearing about this, first thing we would need is protect the innocent, because when you start naming names, you get people who've really been defrauded being worried about retaliation. But I think it would easily be $100 million a year. And we say that because for every small carrier who gets ripped up with $20,000 worth of claims and go out of business, there's probably some big guy who is losing 4 or 5 million. And they really, as you can understand why, they don't want to broadcast, but they're just at the same misends that the small guy is in terms of how do you deal with it. And we can cover that if you all want to, but very clearly, there's enough coalition of people, and I'm talking here about shippers, brokers, carriers, forwarders, factors, that all see this as the bane of their existence. To make a cogent case that somebody needs to address this, and that this not my job has got to end, and that's why I said there's a need for criminal prosecution. At the end of the day, they start talking about civil penalties and whether somebody can go out and charge somebody $10,000 corporation, which has already disappeared, and whether that'll have any good. And most of us think that only serious jail time will affect it. And we've got some ideas about maybe how that should be brought about. So I'll stop there, Jenny, and see if I can get an amen from you or what you'd like to add.
Amen. But one thing that I've noticed over the 5 years that I've done the collections is that when we used to recourse when the broker didn't pay or it was a fraudulent broker, we'd recourse back to shippers or consignees, whoever the arranger was, and other beneficial parties. Whenever we would reach out to them and say, "Hey, this final mile carrier didn't get paid," generally those liable parties would be racing to the phone to say, "Don't report us. Don't contact our customer. Let us pay you. We'll take care of this, whatever." And today it's totally different. Nobody wants to pay. Nobody wants to pay. Not the lead broker, not the shipper, not the receiver. Everybody wants. We paid who we hired. They don't want to pay anymore. They're putting their feet down, and it's getting harder and harder to get those liable parties to pay.
Well, but see what you said is something that I've translated over time, and that is you can't get them to pay. What you're asking them to do is based upon the assumption that they are ultimately liable for your bad decision to extend credit to a crook. Now, if I were an arbiter, I would tell them, look, you guys ought to work this out. You ought to split it.
Mm-hmm.
Look, I'll just pick a name. Look, Coca-Cola. This guy is an honest man. He got crooked. You should have had a position in place to verify that the guy that picked this up was the guy you hired. So why don't you guys split the difference, or why don't you agree if he's operating in your traffic lane that you'll do business with him till he halfway earns it back. But what happens is the old law, if you don't know history, you're condemned to relive it. The old law was based upon what was called the filed rate doctrine. Under the filed rate doctrine, whatever was going to be charged by that carrier was on file in Washington. And there weren't 14,000 people all in the same operating thing. So the issue wasn't there, and it was very easy for Hohenwald Truck Line to go in to everybody in Hohenwald and say, I delivered this. You're the consignee on this. I had to make the delivery because I'm a utility and I was told to deliver to you. You ought to know your consignor, and you ought to know that what my rate was. I had to serve you. So get straight with me here. Right. I'm the one that shows up every day at your plant, and you know what my rates are. And when you unloaded my truck, you knew it was me. Now it's not my fault. It's not my fault that whoever you bought the stuff from gave you ran it through his brother-in-law. And so it really the equities of it have substantially changed. And what you'll see is if you're trying to take that that position. And look, I run cases doing that. And it used to be based upon the Uniform Bill of Lading.
Yep.
Everybody had a uniform bill, and the uniform bill said very clearly that as a matter of contract law, there was recourse. There was recourse to the consignor unless he signed Section 7, and there was recourse to the consignee unless he told you before he did it that he wasn't responsible for it. That law went the way with the Uniform Bill of Lading. There is no contractual backup to that anymore.
Yep.
So you get Baxter Bailey and all these people coming in and saying it's Hornbook law. Look at the date of the law. It's before the passage of deregulation. It's before they put into law the fact that the shipment who's subject to a written contract, if any, then subject to the carrier's terms and conditions which are published. It doesn't say that every shipment moves under a uniform bill of lading. So, what happens is, from my point of view, the collectors who are just saying, well, look, I know my client's name's not on the bill of lading. I know you weren't intending to pay this, but there's some sacrosanct law that says if I'm hoodwinked, you're going to pay me. So I'm just saying that the equities of that exchange. And one of the things that really concerns me, and Jeannie, I hope I'm not offending you with saying this, but a lot of these collectors basically go in and they say, look, you sign this and we'll take 60, 70% of whatever we get. So at the end of the day, the poor dude who got defrauded is basically giving up half of his money when he hires the collection agents.
Yep. So, and
then what happens is if you're representing, and this is a situation I'm put in frequently, I'm representing a small broker who, excuse me, who got double brokered, and he's got his biggest customer calling and saying, I don't know why this happened, but somebody's threatening to sue me. Make it go away. And, the lead broker has been just as defrauded as everybody else because he's put it on the call board. And meanwhile, whoever set up the call board maybe knew or should have known that, this guy was a fraudster in the first place. So it gets very morally ambiguous.
Yes,
and
absolutely does.
To me, the real issue is let's come together and say it's criminal fraud, and it doesn't matter whether you've got double brokered on the front end or on the back end. We're honest people, and we want to see that this gets stopped.
And I'll say that John and I both work towards those kinds of resolutions. We try to get both parties involved as adults and come to the table. Unfortunately, there's a lot of adults in this industry. But absolutely, we do try to do that. Now, I also, will explain to my clients coming into it, look, you didn't do your due diligence checking your broker well, just like that broker didn't check that carrier that they gave it to well. Because that's where the fraud came in. And so I often have them split that difference. I explain to them the rates inflated. We can't ask for more. We can't legally ask for more than what they've posted the rate for initially. So I always ask that broker for their original rate posting to show that's what they posted it for. And then we work down from there and try to split the difference, really. I just want to see that, the basically I tell them, I said, you're not going to come out ahead on this. You're not even going to come out even on this. The whole point is that if you get hit with more than one of these as a small trucking company, it can take you out. So if we can mitigate the damages and at least cover your fuel and your costs, then at least you're not going to go under with one of these. So
I think we've got a good basis of understanding, and I understand that what you're talking about is economically reasonable. But most of the guys that have been doing this as long as I have learned that with the collectors, that if you once establish this idea of they go tortiously interfere with your contract with your customer and tell him, first of all, we're going to sue you unless you pay. And then when the guy says in response, well, look, I'm not going to pay you, take it up with my lead broker. And then you hear the Cheshire Cat laugh, and he says, oh, well, that guy pays off all the time. If he doesn't pay for you, there's something wrong. So from the point of view of sizable brokers, if they once start giving in, they'll people will go out and hunt for situations
But
to
by
bring
that
cases against them. I mean, they're like preferred prey. So a lot of shippers of brokers have to take the position. No,
but
it's
by
it's
that
really
same
a nuisance. It's really a nuisance suit. Bring it on.
hmm But by the same token, just as much as those lead brokers are involved in it, some of them, I tell them all the time, the mega brokers out there, you're what everybody's eye is on. Everybody's looking at you. So you need to be setting the standard for the industry. And so not that they have to always come to the table every time. It might not be their fault, or there might be something else that happened. But by that same token, I mean, I was granted transparency for the second instance, right behind Pink Cheetah against Uber, but Uber Freight went into their situation eyes wide open. They knew that the load was double brokered before the carrier ever moved it. The carrier said, I want to just return it to the shipper right here. He was right outside the gate. So I'm just going to return it here. There's too many hands in it. And they said, no, that's the last thing we want you to do. Go ahead and haul it. You're going to get paid. Well, then that broker that was in the middle, closed down on within 15 days of him hauling that load, and they didn't pay him, and then he recourse back to Uber saying, hey, you said I was going to get paid. This broker didn't pay me. Now what? And they just totally ghosted him. And so I had to I went after Uber and said, you had that rate con from that fraudulent broker before he ever moved the load, and you told him to move it anyways, and you told him he would get paid. You need to come to the table for him. So something like that, where
Well,
they went
listen,
into eyes wide
as far
open.
as I'm concerned, just from what you said, you've got an exception to the rule, and
Yes,
I don't take the position that
of the exceptions.
the bill of lading is sacrosanct and all of
Mhm.
this. I'm just saying, don't bring me cases
Right.
that I know were litigated when the ICC and the file rate doctrine was on,
hmm
and tell me that that's still applicable law. But anyway, that's really not where I kind of like to focus some of this.
hmm
It really is tying down to the role of the broker with respect to the funds they collect and their criminal culpability or not taking the money in trust and transmitting it to the carriers. And I'd like to,
Yeah, sure.
however many people are listening, make this point. The broker regulations haven't changed. If you read them, they are a model of simplicity. What they say is that the broker is not a carrier. It's an intermediary who arranges for transportation. And it's an intermediary who comes into possession not of cargo, but of funds. And just like the carrier is responsible for delivering the cargo intact, the broker is
Delivers the funds.
responsible for receiving the funds, segregating it from any other business he's in. And if he hasn't prepaid the carrier with his own money, being able to show that that money came into a trust and went to the carrier that was hired. Now, if you take that from a starting point, you can follow the law and find out very simply that there are federal statutes that talk about embezzlement. You've probably heard of the term embezzlement. It's a legal term. It's a cause of action that can be brought against someone who has a fiduciary responsibility to handle somebody else's money, and it applies when he goes and misappropriates. If he misappropriates it with felonious intent, he's going to jail. If you can get the government to prosecute him, okay.
If
Getting the government to prosecute him particularly if it's the FMCSA, is just hitting a brick wall. Now, I can tell you that those of us who have seen all of these things about, there's the bond, we'll increase the bond money, all this other little heebie-jeebie, ain't about to make a dent in fraud.
No.
They're scraping too much off the top. If because it's, quote, white collar, and I disagree that much all of it's white collar. As soon as you get threatened by some dude that says, just pay me my money, I know where you live, you'll realize that there's some hit them upside the head threat here. But the ultimate issue I'm trying to make is that the commerce is an exception to everything else. Only the federal government can go across state lines and chase criminals in our industry. It has to be something that you don't think you're going to go to Pensacola and get them to pick up a case for prosecution against some scam artist in Omaha. It doesn't fit their profile. The only guy that's going to do that is somebody who's got a nationwide profile and can be shown by the FMCSA or whoever collecting the data. Look, this guy's stolen 800 loads. Look, they're 10 loads of copper wire that disappeared from the same warehouse in Chicago. Face amount, $3.8 million. Go get them. Go get them. And then when you get to the point, and, I know Dale's driving, but Dale's as good as this as anybody I know, that, you can connect the dots and you can say, look, this guy's is a third generation member of the 909 gang. He's got the same ethnicity, okay? And they're still at it. And the last heist is worth $800,000. Don't tell me we can't find him. And don't tell me nobody's looking. Now, at some point, if you're as involved in the industry and you love it as much as I do, you got to say, this just ain't right. And that is, that's the basis of, I guess, my adamancy here. And I guess it causes me to ball up a little bit, particularly when I hear these people that don't understand the law or know where it's come from. And these people that are actually in charge with the National Transportation Policy. And if they read it, they know that its intended purpose is to lead to a safe, efficient, economical transportation system that has a special place in its heart for small business entities. They can be owner operators. They can be people who legitimately need to have reputable carriers in order to facilitate them choosing their routes and getting enough money to live at home, be home for the kids' football game, or whatever else it is. It is, in fact, a choice, not a sweatshop on wheels. And on that issue, there are certainly regulations that are enforceable to keep bad fleet operators from abusing. I'm just saying, I'm not such a deregulist nut that I think just let caveat emptor, let the buyer beware. You need to have enforceable rules that clean up an industry. And let's face it, we got an industry that's in real problems.
So out of your experience, what's the first step? What is the first step that either the government or the industry needs to take to start cleaning this up?
I think that the first step is to stop the agency from, or the new agency from playing hidden ball with the question. It's clear that whatever they're talking about in terms of a new application might have some effect in terms of identifying the bait and switch thing, where some guy opens up a brokerage, the same in Rancho Cucamonga, that he opens up a carrier in Diamond Bar and runs it for 3 months and walks off. Maybe you can catch that kind of thing, but the larceny by fraud, the just plain scams conducted by people who aren't licensed, authorized, and insured to begin with, means that there's no way that the solutions they propose are going to have any real effect on the master of it. The only way it's going to have any effect is if we ultimately go to Congress with, I think, the whole idea of small carriers, large carriers, whoever they are, going to their congressmen and senators and saying, listen, we want to tell you how bad this is. We want to show you the examples. We want to show you that there are federal statutes on the books that need to be enforced. And I think that that is the only way that you'll get, if you get congressional action. And basically, I don't think the FMCSA has any basis to object. I just don't, frankly, think that they feel they're equipped to do it or want to do it.
Now you're referring to the new fraud team, the registration fraud team that was recently brought on with FMCSA that is looking at front door options in trying to screen out the bad guys. That's what you were referring to before. I know,
I'm not really. I don't think they have shown, as they're required to show under the laws, that A, it's going to be cost effective, B, that it's going to have any ultimate effect. Guts of it are that you'll electronically file your application. It will be processed to determine if the guy's where he lives, if he's got any kind of past affiliation. All of that is kind of gee whiz. Certainly the facial recognition, the use of AI and all of that seems to be where the country's going. But then you've got to ask yourself, if the ultimate issue is to catch and penalize fraudsters so that they get run out of business, how is this system going to make a dent in that? And that's what hadn't been shown. I guess my concern is the idea of advancing this to the stage it's in now only occurred after the election. It only then elevated the application process to being even considered as a rule. And as long as I thought that was being coupled with doing something about prosecuting criminal fraud, I could probably certainly accept that. But I think it's an excuse, not a reason. And I think that the fact of the matter is that there are so many cases that have been made and handed to the FMCSA where it wasn't a question of, is this guy a dirty bird? Here we got the proof. Here we've got take an example. There's one that we presented to the FMCSA, a broker fraud. The broker had done that Rancho Cucamonga Baytown next to it. Applications filed the same day. 9 months later, the the broker files bankruptcy, $1.9 million built out of the system, $75,000 paid, over 120 motor carriers defrauded, facts turned over to FMCSA, prosecution. So, I mean, you know, I guess my question is, okay, so we're going to go hire all of these people to go out and vet these folks. In the past, when they've been vetted and turned over to the FMCSA, they haven't done anything about it. And so, you know, I would be much more in favor of this if they said, here how it fits hand in glove. But when you ask them, they say, well, we don't have any current authority to even oversee the brokers. You can go to the agency and say, look, and Dale has done it. Look, I can just scrape the FMCSA and show that there are over hundreds of these carriers all operating out of the same empty warehouse. Carriers and brokers, that's against the rules. When you go to the empty warehouse, you've got to ask yourself, are all these people frauds, or why is everybody operating out of this warehouse? Well, you might think, and the agency says, well, we have to give them the benefit of the doubt. Maybe they just didn't know any better. Maybe they made those statements under penalty of perjury, but we can't go after them for that. And then you point out to them that, well, if you start looking at the addresses that they said, or the email addresses that they gave you, when you look at the email addresses and detect that there are a lot of them that have the same email address, and they're all slanderous comments about the FMCSA, and that doesn't infuriate you enough to go out and then say, who's doing this? This is making a mockery of the whole system. You got to say, well, you know, if that's the level of effort that you're going to put at this new system, where's the cost benefit analysis? So, I mean, you know, I'm not trying to cast shade on them. I'm just saying that the dots really aren't connected.
And we have seen these problems escalate over a very extended period of time. Heck, frankly, since deregulation began, we've been watching these problems slowly escalate. Do you think that the new administration and Sean Duffy, when he comes in as the new transportation secretary, that there's going to be any kind of change as to what's going on versus what we currently have at the FMCSA?
I don't want to get caught trying to handicap what will happen. I don't think that the new director is by any measure someone who has experience in the industry, who comes in with a reformist attitude. Now, so, you know, am I expecting anything necessarily positive there? No. I think he'll have to be educated. In terms of the advocacy, what we're saying the new administration should be helpful with is getting back to what we call the administrative process. In order to change laws that affect an industry, you have to go through a rulemaking process. You have to show a cost-benefit analysis. You have to consider the effect on small businesses, and all of those criteria make it a little more cumbersome to change the rules, but they're intended to use the idea of the federal government to put to restrict the ability of an agency to go rogue, and to be sure that the precedent for what they want to do is met. Now, in this case, when you're talking about changing rules, or not even having a rulemaking to change an application, you can find that the agency has to admit that a rulemaking is necessary. But then they try to find ways around conducting it. So, for example, every motor carrier and every broker has to have a list of agents in every state. Okay. That's built into the regulations. Uh, there's no policing of the agents. So the agency wants to make these resident agents and the people that help people do the applications. You call them, applicant helpers or consultants. Wants them to have keys to the switch to get in and manipulate carrier identification. But they admit that those people have to be regulated. They have to be vetted. And, based upon the quality of the people that are there now, and there are 70 of them that act as resident agents, and probably more that, do it as an offset of fuel taxes or whatever. They're not vetted at all. So, a lot of what they show as misappropriation of addresses are done by the people that are filling out the application. Well, it's going to be Two Truck Charlie. He doesn't have a principal place. So you've got all of this issue. When you get through with it, if you're going to turn over the keys to changing the identity to a third party, you got to vet them. So now, if you got to vet the third party, how long is that going to take, and how effective is it going to be? Particularly when it appears as though a lot of the fraudulent filing of applications is directed not at the guy that comes out of rural America or is just gotten his green card, even understanding what's being filed. So I'm just saying the devil there is really in the detail. I guess most of us that have been doing this a long time say that if you're really going to curb the tough stuff and be effective, you're going to have some convictions. It's just too easy now. Some of these people, change addresses as often as they change underwear, and there's no real policing. I'm sure that in y'all's line of business that you've seen exactly that.
So let me pull back a little bit away from the Fed and look closer to the brokers and carriers as individual entities. Do you really think that brokers may not have a full understanding of what their role is, especially with new brokers that are coming in constantly, whether they be coming in under the agency model or if they are just coming in and starting a new one or two mom and pop brokerage type situations, and even on the carrier side, where other than at the Fed can efforts be placed in trying to fix things when it comes to fraud within the industry, in your opinion, at the carrier broker level?
I think there are, there are all different kinds of flavors of fraud. There are people who can't pass the task, the task of saying I was just ignorant. They entered it with the intent of embezzling the money and knocking over the popcorn stand and going ahead and doing it again. They've got a track record. Okay, now that's an embezzlement scheme, and when you drill down and they've got phony addresses. This is the third time they do it. It's part of a criminal scam. Then I think even a guy who doesn't have any training on what 371 has got to know that he's embezzled somebody else's money, and that but particularly when you get these new guys in that, let's face it, don't have any business background and haven't even been tested by the FMCSA to prove that they understand the rules, they'll go in and say, well, gee, I'm starting a brokerage and I don't have any money. I wonder if I can find a factor. I can find a factor who'll take the, and there's some people out here as factors that don't recognize that when they buy that receivable, all they bought is the margin. Okay, they say, well, I'm a secured creditor now. If this guy goes bankrupt, I'll be the first man in. No, not quite so here. Factors should be sophisticated enough to know that unless they see that the proceeds from what they have paid their customer is passed on down to the carrier, that they can very easily see that carrier in bankruptcy court. Because when that dude goes bankrupt, we would tell the carriers to file not just as a general unsecured creditor who finishes last, but to file as a preferred creditor and to say, look, I don't know who thinks he bought that thing, but if he doesn't get any UCC preference on money that wasn't the debtor's. So if you follow me with what I'm saying is, realistically, carriers need to be a whole lot shrewder when this kind of things happen. It's recently happened, I think, with Convoy. Household name. Who would think the Convoy would file bankruptcy and end up stiffing motor carriers on receivables for brokerage? Now, it hasn't been fully tested, but there is a case that is sticking in a lot of people's side, and it involves a guy that I don't think had a larcenous heart. I really don't. I think he was a decent guy, but he did not understand that there was a constructive trust. He just simply, I guess, got between a rock and a hard spot. Maybe had mortgage payments due, took money that should have gone to the carriers and just was upside down, but didn't realize that he was bankrupt on the money that belonged to him. And now he's being faulted all over the industry of being an example of somebody that seemed to be doing things right, but basically whatever he did with the money, he didn't pass it to the guy that was there. Now, my analogy to this, and y'all can pick at it if you want to, but I'm a lawyer, and as a lawyer, if I collect a settlement from somebody and they pay my law office, that ain't my money to spend. If I'm working on a 20% commission, I really don't work on a commission, then I can hold that out of the proceeds, but the rest of it would be embezzlement if I took the money. And I would assume that, I would advise you, if you were in a collection business too, that, if somebody called me and said, hey, my collection agent collected $1,000 and I can't find them and they owe me $800, I'd be saying, sounds like embezzlement to me. I know with respect to real estate agents, stock brokerage, and those kinds of things, it doesn't matter what the industry is. The definition of embezzlement is broad enough to make that punishable by criminal penalties, and certainly subject to civil penalty.
Now, I'm kind of curious. There's a lot of things going on through the industry right now. We're coming up. We're about 55 minutes in, so we need to start winding down here in a few minutes. Very big right now is the transparency issue. 49 CFR 37. What was that? 341.3, 371.
371.3.
Thank you. I knew I had it in there. Sorry. It's Monday. Give me a break. What is your stance on the whole transparency thing? We've had a show on it a couple of weeks ago, but I'm kind of curious how you feel the whole transparency fight is.
I do not want to take an advocacy issue on that that would heighten the level of animosity between the players in that. And
Can you answer?
the reason for that is really very simple. I believe that the regulations should stay. Regulations say very clearly that any party to the transaction has the right to see it. I think that serves a very good public purpose, and that the margin is not something that is protected by law or should be. I don't think that with deregulation, everybody said that, oh, well, a 14101B waiver will let us nuke any rule of commerce that is in the book for a purpose. And I think those things were there for a purpose. As I mentioned before, when those things were packed, the advantage of it could only have been that you got to see that the guy hadn't run off with the money, because what the carrier was going to be paid was established by a tariff. So very clearly, if you had a tariff rate that was $1,000 to hold all that load from Hohenwald to Nashville, it was given, that was the file rate. That's what the carrier was going to be paid. So there wasn't this idea about a broker saying, "Well, gee, I think I'm getting screwed somehow because I'm entitled to more." Now, a carrier saying that, from my point of view, I wouldn't stand or fall on addressing fraud because of it, and I think it's really unbecoming that they've gotten into this. I really think that the brokers have created kind of a law of the jungle. And it is, look, we know it's not insurable, but you've got to sign on for this risk. You don't get the loan. I mean, I think that a lot of those contracts contain provisions that the small
Are you
carrier
okay with the waivers? Are you okay with waivers?
Waivers of what?
Like the way in the broker carrier agreement where they ask you to waive your right to 371.3. So that a lot of the broker carrier contracts now, the brokers
I wouldn't stand in the way of it. I do think that it serves a purpose. Now, I think it serves a purpose. I hear the brokers say that, we're providing all these additional services that justify, a 30% margin. The way the rule is written, if they want to say that the load paid $1,000 and that they had a management fee of X or something to justify it, nobody says that they can't accumulate other costs. But you know where most of that cost comes from. It comes from the additional liability that they're accepting as if they were a carrier. If they were just a broker arranging for transportation and hadn't accepted a whole lot of carrier duties in the contract, like payment of the cargo claims, like all of that, then they wouldn't have a leg to stand on for why they couldn't come up with standard pricing. Now, part of the other issue of this, from my point of view, is from the shipper point of view. Now, here comes along a shipper, and he hires somebody on a 3-year contract, and he doesn't pay much attention to it. But whatever the rate is, the rate's fixed. And as part of that, he has turned around to anybody who hauls for that customer and gotten him to sign a statement that says he will not back solicit nor handle shipments for that customer for a period of 3 years. Now, I think that's, a non-back solicitation. I agree it's bad business to go handle a load for somebody and then go back and try to back solicit the guy that gave it to you. But on the same hand, I don't think that if the shipper wants to turn around and put his freight out for bid, and he goes to some carrier, and the carrier says, well, my ordinary rate is X, that somehow that broker has acquired a right to compete the guy, to force the guy to compete in an unfair market. Am I making any sense? Hope I am, because I've had this kind of case in which carrier was the dominant carrier providing service for a major shipper. The major shipper put the freight out for bid, got a rate from a broker. Broker turned around and made the incumbent carrier sign a covenant not to compete, saying he wouldn't go back to his former customer, even if the former customer kicked the broker out. Now, look, come on, give me a break. I mean, it's not like the freight was unknown. It's not like the dominant guy who was providing a PU and PD service at the plant, had.
I feel that it shouldn't be automatic either. I think the carriers should have to ask for that transparency if they want. I don't think it should be a blanket grant 48 hours after the load is hauled. You automatically get transparency, because there's a lot of carriers that may not know the law. A lot of the carriers that don't want to go to the effort of asking for it. So I think that in saying that it's just a blanket automatic give is not necessary. I think they should have to ask for it.
Let me ask you this: what you've got is you've got the MRIS and the standard contracts that have that in as a provision, non-back solicitation, and it's depending upon how it's worded. And when you want to get the load, the contract manager says, you can't change any of this. I don't have the authority to do it. If you want the load, you got to sign it. So, I mean, it's become kind of a dominant rule that, particularly with a lot of large brokers, those provisions are there, and it's take it or leave it. Now, to me, if the goal is to have a competitive open transportation system, I think that's a little too much to carry. And we know that there's, suits all over the country in terms of whether or not those things are enforceable. I'm just saying, it's a matter of public policy. I don't know that. I don't think it's fair business to back solicit somebody.
I was talking more the transparency.
Huh?
I was talking about the transparency, the right to view the transaction. That any party to the transaction has the right to request the records.
Well, are you pro or con for that? I'm not sure.
I'm not either, because I do however it comes down dictates how I represent my clients or whatever, depending on whether they're a broker or a carrier. But I'm just saying, I don't think that carriers should be automatically granted the right. I mean, they shouldn't be, as soon as the load's over, every broker has to automatically give up the transparency. I think a carrier should have to ask for it.
Oh, I agree there.
Yeah, that's what I'm saying.
Oh, no, I mean, I don't think there's any compelling need for that. And in fact, my major concern about that is that they don't take away the obligation of the broker to maintain the records.
Right.
And those records to be subpoenable, to be used in civil or criminal prosecution. I mean, I think otherwise it's.
And those are the clauses.
Otherwise, the whole, it's much ado about nothing compared to the real get you issue, which is the agencies put in an 80-page, hard to understand, last minute proposal that somehow they're looking at changing these regulations that have been in place for 40 years and serve a purpose. And I don't think that unless you were around and know the background of that, understand how morphed it's gotten now in terms of what should be acceptable Hornbook law. And I would hate to see them come out with a rule that said deregulation's deregulation, All we're about is safety. We're going to do away with these rules. Because I think that realistically, it offers us our best shot at bringing some kind of answer to this. Because right now, there just really very simply isn't it.
Right.
And you can say, well, gee, and many people probably will. The government doesn't have the what do you expect out of Washington? I mean, there are a lot of people that say, we'll believe that when the moon turns green. But I guess what I'm saying is, I think those of us who live in that world and recognize how close it gets to unplugging 200 truck operations because you reported them for what they did, which was steal freight.
And those are the waivers I was referring to, Hank, is in the broker carrier agreement, the brokers will ask the carriers to waive their right to the broker transparency. They'll say, you have to sign, you waive your right to 371.3. So you won't get your transparency. You just automatically waive that right. You won't ask for it ever. Do you think that's fair for them to put it in there, and the carrier has the right to decide to choose whether or not to work with that broker based on that?
Look, it's going to take a man of principle, all right, to not sign that if he's desperate enough. Mm-hmm. But I don't think it should be enforceable, because what you're waiving in doing that is not just the fact that you're curious and want to know what the margin. I don't think party to a transaction should be held to have waived their rights if they're defrauded.
Exactly. And I said I think there's a place for broker transparency. I think it's important in our industry for reasons of fraud and determining certain purposes there. However, I don't think it should just be a blanket, grant. But, a lot of the brokers are concerned that this will be a race to the bottom when when their rates get out there and everybody can reverse engineer how they come up with their rates, and they'll lose their competitive edge, and that it will drive the rates down.
There's a militancy on both sides of this thing, okay? And I can readily see that what you're talking about is, this is not a question of principle. This is a question. And when you look at it this way, and you take it to any other industry, if I'm going to go out and buy a washing machine, I'm going to look and see who's got the best price. Okay, and if it turns out that I prefer to do business with Home Depot, but want to go price shop, I should be able to price shop. But ultimately, in that thing, you've got a commodity that has a net value, and the consumer is able to go and choose. So I mean, it doesn't really appear to me to rise to the level that any middleman should be ashamed of his margin. Mm-hmm. Particularly when you've got the price that it's offered is a spot market rate. So I just don't think that the people who brought that, OIDA and the other group,
SBTC,
actually foresaw the extent to which the large brokers would come out with objection to it. And as I can see it, so far they've done a pretty good job of convincing the agency to hold tight on the regs. But gee whiz, guys, people I know that have read that last proposal in that legislation say it leaves a whole lot of question marks.
Yeah, I wouldn't disagree. In my review, without any kind of meat, trying to prevent brokers from putting in the waiver into their contracts. There's nothing in there that prevents the brokers from doing that. With respect to all the carriers and brokers out there, I almost think that this effort is dead on arrival, because if a broker can continue to put that into their contract and say, hey, Mr. Carrier, I don't care if you want transparency, you signed the waiver, therefore we don't have to say anything to you, and FMCSA is not going to turn that back around. And I believe that's because of Article 1, Section 10, the Constitution. I think it requires Congress to interfere with the contractual obligations in order to force brokers to pull that off, if I understand correctly. But because of that, this whole effort, in my opinion, is almost dead on arrival. I mean, I love the idea of transparency. I'd like it in any industry, so consumers or other participants within the industry can make an informed decision, and not just the carriers, but the shippers too. I believe the shippers, as a party to the transaction, should have a right to see what the broker's paying the carriers. And I'm not sure how often that happens either.
But the brokers are saying the shipper doesn't care what the broker's paying the carrier.
When I was a shipper, I care very much what my bottom line is. Where that money goes, I may not care as much, but if I know that I'm being overcharged because either the broker's taking too large of a chunk or because somehow the money's not getting to the carrier, then that is a concern that I would have.
But if the money's not getting to the carrier, the brokers are saying the shipper's just going to take it back. They're not going to give it to the carrier. They're going to take it back, and the rates are going to go down.
I don't know how to respond to that. I've not seen a viable economic model show up that would prove to me that is in fact the case. What I would see is competition improvement between brokers to say, okay, well, this broker has a 20% margin. This one has a 10% margin. But if they can't justify the additional margin based on quality of service, then
so John, you made the most cogent explanation that I've heard of this. You think hidden somewhere in that latter day thing is it doesn't really matter what the regulations show. It's waivable under a 14101B waiver. Okay,
that's where I'm driving at.
All right. Well, look, help me when we get off of here. Send me the language you think that opens that up, because you see, my argument is that when you get to questions that are beyond routes, rates, and services, you can't just say you can waive any and everything. You can't waive safety. You can't waive a whole lot of other things. It's inimical to the idea that you're supposed to have an open, free, and competitive truck transportation system under the FMCSA's requirements and enforcing the act itself. You're going to encourage competition. How can you be encouraging competition if you're telling somebody that he's signing a waiver and can't offer a shipper a better deal?
Well, as we know that when you ask for transparency and you're granted transparency, you're not supposed to disclose the information you get to other parties. But if I have a lane that has 20 loads that are going from Houston to San Antonio, and I've had 20 different carriers hauling those 20 different loads, how do I know who gave up the information if I granted transparency to all of them? They're saying that it's going to become a data mine. The carriers are going to go out there and haul these loads just to get the rates on that lane to give them to brokers, just so that they can underbid their competition and get that lane away. So if everybody out there has the ability to get transparency, yeah, there's going to be carriers that take it nefariously just to get that information and sell it to the brokers or give it to the brokers so that they can undercut their competition.
That's gotten pretty far field. I mean, I guess the question is, that I thought the first job of a broker was to walk into a shipper and say, "Look, I'd like to cut your freight charges. What are you paying? I can save you. I can save you a whole bunch of money. And how much would I have to cut uh, my rates to get your business?" I mean, that kind of cuts both ways, doesn't it?
You think? I mean, there's so many different arguments out there with regard to transparency and why it should or should not happen.
I'm just throwing out. I'm just don't shoot the messenger. These are things that have been brought to me that I'm just saying I don't have the answers for them when they bring these up. I don't have the right answer, the wrong answer. I don't. So just kind of getting some guidance from you, what you've seen in the industry.
I mean, I guess the question that I've got, and I know there are two sides to this story, but the promise of deregulation was that we're going to have an open and free market and compete on routes, rates, and services. Routes, rates, and services. And that when they defied rates, if you're going to compete on rates, then don't tell me I've got to put on blinders as to what the existing rates are. That it not only is that, but somehow I'm getting a competitor to tortiously interfere with contract because he tell me what the rates are. I mean, you go to routes and lanes, and people will tell you that the average flatbed load out of wherever to whatever is going for whatever it is. It's not like people aren't pretty well determining what rates are to tell people what to bid on. So I just wonder how far that can go. And I mean, I guess what really concerns me is to what extent does this tendency, and the shippers have been made fearful that they're going to be sued if Two Truck Charlie hits a school bus, that unless they go with somebody that's big, the cargo claim's not going to be paid. All of these things to, basically hive up the rate. And a lot of those costs are then absorbed by them being self-insured. So, I mean, at what point does a shipper have the ability to say, well, what's my risk proposition? Do I have to go through an intermediary and then lose access to whoever he finds? This may be a honeypot to go home to. I mean, you're a happy man, I guess, if you're a broker. You find somebody on a call board that's got 15 empties coming back to Keokuk, because now you're locked in. I mean, I guess the question is, if I'd hate to say, well, gee whiz, forever and a day you can't haul for this guy, even if he saw you in the front yard and said we're unhappy with the broker. Does that give you guys a sense of concern?
Sorry, I got a dog barking in the background. Go ahead, Jenny.
I mean, as you can see, I'm really kind of reluctant to get into it because I've got people on both sides. I just
That's why
I've just had several cases in which I've tried this. I've seen incumbent brokers try to enforce those kinds of restraints, and it usually comes down to how broad is the covenant. You particularly see it, when some guy comes in and goes in as a salesman for a company. I don't think that's nearly as close a case as a carrier providing service to a broker. But you see lots of cases where, as a condition of a merger, Salesforce is required to sign a statement that says that they leave the employment, they won't backsolicit anybody for 3 years. Mm-hmm. And courts have a lot of problems with that.
Yep.
Well, Hank, I want to thank you for your time. We're really starting to run over, and I need to start putting this short. You have
Yep.
an insane amount of knowledge
Information. Yeah.
on all this stuff in this industry. I think transparency is only one of the most immediate issues that the industry is facing. I think a lot of the issues with regard to constructive trust is more of a longer term play. That is something that both FMCSA and brokers need to work out in a better way. And I do think that steps are being taken in the right direction, at least by FMCSA, in trying to secure the front door when it comes to trying to stop scammers from getting authorities in the first place. Whether or not that's going to translate to improvements on the back end is going to be something that I think we're all going to be very interested to see whether or not there'll be any kind of impact in the not too distant future. And whether or not the change in the administration is going to have any kind of impact towards that is also something that is going to be interesting to watch over the next 6 months or so, with whatever initiatives the new secretary is going to try to bring to the table. There are a ton of things that are going on, but I would love to get you to come back and have some more discussions with us on some of the other policies and things that FMCSA is trying to push, or things that some of the other advocacy agencies are trying to push, because there's definitely a lot of balls being juggled in the air, and you have a very unique perspective on a lot of this that I think most people don't understand. You want to give a quick plug on your book and where interested carriers and brokers might be interested in trying to obtain that?
Sure.
Jenny holding it up there, Rules of the Road.
Yeah, the book is called Rules of the Road. My law firm website is transportationlaw.net. Transportation Law written together.net. And if you want to know a little bit about our firm and the types of cases we handle, I'm blessed by having people that have been with me, 20 or 30 years. So I guess our collective knowledge on some of these things, if they're still relevant, is really pretty current. The other thing is for the past 20 years, we've been supporting advocacy, and we have a number of small trade associations that go all the way from auto haulers to air freight people. Includes trade associations represent shippers and brokers and other folks. We really basically committed to free competition and to trying to work together. The issues we cover, you can probably guess, are fraud, owner operator safety fitness determination, uh, the requirements of federal statute that agencies don't get too far off track without giving due process. And if anybody is particularly interested in any of these elements, particularly in terms of following them, they can contact me, and we can put you on a list to receive a monthly update. It's kind of a legislative update that you kind of follow it maybe
Excellent.
with a
Excellent.
little more specificity on legal issues. Clearly, the things we've talked about tonight are things we.
Hank's email address is on the screen here in case anyone wants to try to reach out to him. I don't know how easy it is to get a hold of him by email. I'm sure you get emailed by a lot of people. But Hank, thank you so much for being with us.
Glad to do it.
Fantastic. And we will definitely have you back in the not too distant future to cover some of these other things that are going on. Jenny, wow. Oh, I'm so glad you were able to step up and help me out this evening. I really do appreciate it. You got any parting thoughts?
No, just thank you so much for coming on. You're a wealth of information, and I'd love more time with you in the future whenever.
Well,
John
thanks for
buying
my book. I'll be sure. I'm
worth
glad you got.
it.
I'm glad you got it. I'm glad you got it signed, Jenny.
Yep. Thank you. Thank you. I really appreciate
Sure.
it. And then we'll look forward to seeing you the next time. Thanks for having me on,
Okay.
John. I do appreciate it.
Okay, we've got to show some love real quick to our sponsor, AccuBid Pro.
Do you know your cost per mile? Have you been hitting your profit margins? Do you struggle with bidding in a way that is both profitable and competitive? Would it be worth it to have all this information right in front of you? By calculating your cost per mile, AccuBid Pro helps you stay profitable in an industry still struggling to recover. In order to calculate your cost per mile, AccuBid Pro asks you questions about your business expenses. Our goal is to help you understand what you need to keep operating in order to keep up with the game and maintain your business. Enter your origin and destination, and we show you what you should bid based on your personal cost per mile in order to be profitable, even including a more detailed breakdown of each bid. Download the app today and get your 30-day free trial of AccuBid Pro, available on the App Store and Google Play. Bid smarter, bid faster, bid better with AccuBid Pro.
We'd like to go ahead and remind the audience that this is the website you need to go to if you want to file comments with regard to the broker transparency rulemaking. Deadline for those comments is January 21st, about 3 weeks from now. So if you have something pertinent to say and you are in the transportation industry, by all means, please make a comment. Also, Stop the Scam, as you all know, airs live Mondays, 5 p.m. Central on all the Lounge Media Group social media outlets. Please be sure to like and subscribe and make comments during and after the show. We will try to get to these comments as often and as quickly as we can. Whenever you find yourself in a jam and you think you are dealing with a scam load, you can always get a hold of Kate at kprice@rockdovefs.com, or myself, the Double Broker Bounty Hunter, at jcantera@vigilanttransport.com. This is our last show of 2024. I hope you all have a happy new year and that you stay safe throughout the holiday season. And whatever you do, don't let scammers take you for a ride. Have a good week, folks. We'll see you next week.